Hello, everyone. I have the pleasure of introducing to you Gloria Lim, the new Chief Executive Officer of the Singapore International Arbitration Center, who will give the welcoming remarks and open the Young YSIAC Conference. Before assuming her role as the CEO of SIAC on the 1st of November this year, Gloria was with the Singapore's Ministry of Law, where she oversaw the development of Singapore's legal sector, including the development and promotion of the international dispute resolution regime in Singapore. Gloria also heads the Singapore delegation involved in the discussions on dispute settlement in the United Nations Commission on International Trade Law. Gloria graduated from the National University of Singapore and is called to the Singapore Bar. She also holds an LLM from Harvard University. We're very pleased to have Gloria with us today. Gloria, the floor is yours.
Thank you, Kate, for the introduction. And a very good afternoon, morning, and evening to everyone, wherever you are in the world. It is my pleasure and privilege to be opening the 2021 edition of the YSIAC Conference. We have an exciting lineup over the next few days, and I would like to express my appreciation to the members of the YSIAC committee who have invested significant time and energy putting this event together. I would also like to thank all our speakers and supporting organizations for your enthusiastic support. Today marks a new milestone. Since the inaugural YSIAC conference in 2015, this is the first time that the conference is being held virtually, and we will be leveraging technology to experiment with different interesting formats for our discussions in the course of the conference. We are privileged to have participants from all over the world across 24 time zones joining us over the course of the 3-day conference. So thank you all for making the time and effort to join us virtually from wherever you are. The YSIAC community is truly an international one. Leveraging digital platforms has given us the opportunity to reach out to more young and aspiring arbitration practitioners worldwide. Since last year, SIAC and YSIAC have held more than 100 online webinars with participants tuning in from all over the world. Today, we have thousands of YSIAC members from over 100 jurisdictions. We are heartened and privileged to serve as a platform for young professionals to work together to address the unique challenges faced by the legal and business communities across a diverse range of jurisdictions and cultures. Under the leadership of our stellar YSIAC committee, held by co-chairs Daryl Chew and Wendy Lin, we hope that this platform will provide you with many opportunities to learn from leading arbitration practitioners, as well as network with like-minded peers and participate in events. For example, later this evening, the winners of this year's YSIAC writing competition will present their winning debate speeches at the webinar. If you have not yet done so, and you are under 40 years old, I encourage you to join the YSIAC community and to organize, participate, and connect through our various programs and workshops. You may sign up through the form in the YSIAC section of the SIAC website. I turn to the exciting events lined up for you at this year's conference. YSIAC has put together a series of webinars on hot topics in emerging areas in today's international arbitration scene in a variety of creative formats, including interactive sessions such as speed conferencing. We have an upcoming panel shortly on ESG disputes, an area that has seen an exponential increase in interest in recent years. Subsequently, we will also explore the impact of cryptocurrency, blockchain, and NFTs, as well as review the global arbitration landscape in the Americas and Asia Pacific. We are also privileged to have two prominent speakers, Kim Min Yam, Director Legal at Netflix, and Zhiyang Fan, Head of Digital Trade at the World Economic Forum, who will hold ArbXTalk sessions to share their perspectives and dispense career advice. We look forward to all the events and welcome your active participation. Registrations for all the events are still open and are free for all to attend. Do encourage your peers and colleagues to sign up as well. The global landscape is fast evolving, and likewise, international arbitration practice is developing in response to changing international trends and developments. We hope that this conference will provide fresh food for thought and useful insights for the arbitral community. Looking ahead, I also look forward to working closely with YSIAC to explore how we can do even more on this important platform to serve the needs of young practitioners, to increase opportunities for learning, gaining international exposure, and useful networking opportunities for our YSIC members going forward. I wish everyone a fruitful YSIC conference ahead. Thank you.
Thank you very much, Gloria. So welcome to the first of a series of webinars during the Young SIAC Conference. And today's webinar is called Resolving ESG Disputes Through International Arbitration. My name is Kate Apostolova, and I'm a lawyer with Freshfields Brookhouse Deringer, and I will guide you through our discussion today. So starting with, what is ESG? ESG is the new buzzword in the legal profession, and it stands for environmental, social, and governance issues. And today we will be discussing those types of disputes. So environmental, social, and governance disputes, and specifically whether they have been and should be resolved through international arbitration, whether it's commercial, construction, or investor-state arbitration. And why are we talking about ESG and ESG disputes? Well, for a number of reasons. Obviously, because it's important for us as lawyers and for our clients as well. ESG is on the top of the agenda of a lot of our clients, and it's on the top of the agenda of the legal profession as well. Globally, ESG matters have been growing in prominence among law firms, and Thomson Reuters actually report that 42% of its law clients have separate ESG practices as of June of this year. We're talking about ESG because it concerns what is socially responsible to do. So it provides a set of standards that indicate whether a company or an organization or an individual operates in a socially conscious manner. So environmental criteria consider how a company performs as a steward of the environment. Social criteria consider how the company manages relationships with its employees, with its suppliers, with customers, with the communities where it operates. And governance deals with the company's leadership, with internal controls and shareholder rights. We're also talking about ESG because any ESG dispute can potentially have a profound impact on our clients. ESG issues go to the heart of a company's business purpose and reputation and values and relationship with the community. We're also talking about ESG because Young SIAC is based in Singapore, and Singapore has been focusing on ESG issues for the past several years. So this year, for example, the Singapore government introduced the Singapore Green Plan 2030, which sets out ambitious targets to green 80% of all buildings in Singapore by 2030. There are laws in Singapore which now require disclosure on ESG issues. There has been significant growth in the green finance market in Singapore. And we at Young SIAC want to join the discussion in Singapore and globally. We're also talking about ESG because while ESG has so far mainly touched on corporate and regulatory issues, the legal community does expect more ESG disputes in the future as well. And this is because this rising importance of ESG in the commercial context is likely to lead to an increasing number of ESG-related disputes. And given that arbitration remains the preferred dispute resolution mechanism in relation to cross-border commercial activity, it's likely that a significant number of those ESG disputes will be resolved through international arbitration. In addition, regulatory changes in relation to ESG may also mean that ESG issues arise more frequently in investment treaty arbitration as well. And that's where we, arbitration lawyers, come in. And that is why we at Young SIAC wanted to have a discussion with you on ESG disputes. So for today's webinar, we have 7 distinguished speakers. They're divided into 3 teams: the environmental disputes team, the social disputes team, and the governance disputes team. Each team will first give you details about what their type of disputes are, and they'll provide some examples of arbitrations where that type of disputes were resolved, including commercial, construction arbitrations, and investor-state arbitrations. Next, each team will also tell you about some of the legal and practical issues that have come up in their type of disputes. And finally, each team will also identify for you trends and themes and lessons learned from resolving ESG disputes through arbitration. So this is the agenda for today's talk. And we want this to be a very interactive session, a discussion with you. And we want to talk about what you in the audience are interested in. So to that end, please do ask questions throughout our discussion. You can type them in the Q&A box that you see in Zoom, and I will ask the panelists to address your questions during their remarks. So don't wait until the end. Ask your questions as we go along the discussion. So now we start with environmental disputes. And on that, we will hear from Kartiki Mahajan and Jennifer Lim. Kartiki is a counsel in the disputes practice of Shardul Amarchand. He is triple qualified to practice in England and Wales, New York, and India. He focuses on international arbitration and has experience in representing clients in ad hoc and institutional arbitrations across various industries. In the sphere of ESG disputes, Kartiki has experience in representing private equity investors in relation to their post-M&A disputes in the green technology space, and advising on a potential investment treaty arbitration against a South Asian government with respect to policy changes in the renewable energy sector. Jennifer is counsel at Sidley Austin, based in Singapore. She focuses her practice on international dispute resolution and arbitration, and has represented clients in investor state and commercial arbitrations. Jennifer has worked on a number of international disputes raising environmental law issues, including the Parenco versus Ecuador case, in which Ecuador raised counterclaims alleging breaches of environmental law, and a case in which an NGO asserted claims of breach of a regional treaty based on a state's failure to enforce its environmental laws against certain oil companies operating in that country. So thank you very much both for joining us today, and the floor is yours.
Thanks, Kate, for the introduction. Good afternoon to everyone. Good evening, good morning, depending on which part of the world you are. I just chose a preference for afternoon because I'm based in India, like Kate said. In terms of my presentation, since we are focusing on environmental disputes, both Jennifer and I have divided our presentation into 2 parts, where I will deal with commercial arbitration and Jennifer will deal with investment treaty arbitration. In terms of my own presentation of commercial arbitration, I will break it down into 3 parts. The first part would be a 1-minute introduction to the concept of commercial arbitration in environmental disputes. The second would be the kind of disputes which are there in commercial arbitration in the environmental sphere. And the third would be my practical suggestions, which are formulated on the basis of my own experience in dealing with environmental disputes. Moving on to the first part, which is what the concept of commercial arbitration in environmental disputes is. Just to give you a bit of context, I know Kate said that ESG disputes is the buzzword. Gloria said that there is an increasing rise in ESG disputes, increasing interest in the rise of ESG disputes. What I want to say is that an increase in environmental disputes is not only an interest or a buzzword, it's actually the reality now. And the reason why I say that is because the UNEP, in its report on climate change litigation in 2020, said that the amount of climate change related litigation has increased from 860 cases up until 2017 to 1,560 cases in the year 2020, which just shows it's almost double. And that is exactly what is being experienced by various arbitral institutions around the world. We've had studies by the ICC as well as the Stockholm Chamber of Commerce, which have dealt with different aspects of green technology and climate change related disputes. Now, the unfortunate bit about commercial arbitration is that you don't get to see that many awards in the public domain. So what I have done is try to analyze the kind of trends that you have seen in disputes in relation to environment. But before I deal with the kind of disputes, I want to define what I mean by environment-related disputes. By environment, I'm trying to interpret this term a bit broadly to include not only climate change and conservation measures in relation to environment, but also renewable energy and green technology. Because all of these green technologies and renewable energies are there to foster green practices of the environment. With having said that, I would now like to define three categories of disputes that I have come across when it comes to dealing with environments. The first category of dispute is disputes arising in relation to international commitments like the Kyoto Protocol, the Paris Agreement. The second category is a plain vanilla commercial dispute which arises when a company tries to reduce its greenhouse emissions and it starts investing in projects which deal with green technology, climate change related environmental measures. The third category of disputes are just commercial contracts between the companies, which have nothing to do with environment, but may still nonetheless involve an environmental angle. I'll deal with all three of them broadly when I deal with them individually. The first category of disputes is disputes arising in relation to international commitments like the Kyoto Protocol and the Paris Agreement. As we talk about ESG disputes today, we all know what is happening in COP26, in which there are increasing commitments being made by world leaders in order to ensure that the net emissions reduce to zero. Now, when the Kyoto Protocol happened, it came up with two mechanisms which are very crucial in terms of dealing with environment-related disputes, which is the joint implementation mechanism and the CDM mechanism. The reason why I say that they are quite crucial is because the PCA has environmental rules and it has actually seen disputes arising in relation to these mechanisms. Just to give you a brief background in relation to these mechanisms, the JI mechanism, which is the joint implementation mechanism, deals with measures which a developed country ends up taking projects in another developed country, or any company which is established in a developed country ends up taking in another developed country in order to reduce emission targets. The clean development mechanism is the opposite of it, in which a developed country ends up taking certain projects in a developing country, or a company based in a developed country ends up taking certain projects in a developing country. Now, what happens is that once you do undertake these projects, you're given emission reduction units, which are also known as Kyoto units. And it's in relation to the sale and purchase of these units that you can actually have disputes. Now, unfortunately, like I said, the problem with commercial arbitration is that you don't get to see awards. But fortunately, the SEC in its report on green technology did mention one of such disputes that the PCA ended up handling. In that dispute, one claimant entity entered into a contract with the respondent entity in relation to setting up a project in a developed country. In relation to that project, it got never completed, as a result of which the claimant entity sued the respondent entity. The respondent entity took a defense that we cannot actually implement this project because the host state has withdrawn from the protocol. Now, what happened to that award is very difficult to predict because that's all what the SEC report says. But what it says is that there are possibilities in which these projects can lead to breach of international obligations, or how these international obligations can come into play in a strictly commercial context. The second kind of disputes that can come out of international commitments like the Kyoto Protocol are emission reduction disputes. You have the emission trading system, which EU is a pioneer in. And in relation to that, you can actually buy and sell emission reduction units. In relation to those, there can be certain disputes. One such dispute, which again the SEC had come before it, was in relation to two parties entering into a commercial contract, such that the respondent was supposed to supply emission reduced technology by an X state. Because the respondent could not supply that technology, the claimant actually ended up getting penalized by the Environmental Protection Agency of that country. And in commercial arbitration, the claimant ended up asking for reimbursement of the penalty amount. So these are the kind of disputes that end up coming forward when it comes to emission trading system. The third kind of disputes, which you can see in relation to the international commitments, are sustainable finance related disputes. And by sustainable finance, I mean disputes in which the state-sponsored banks, the state agencies, multilateral agencies, they end up financing a lot of green technology, clean technology projects. Now, under these projects, there are financing documents which say that you have to achieve certain emission targets by X date. And if you don't end up doing, then possibly liquidated damages can be imposed, or if it's unliquidated, then damages can still be claimed in a commercial arbitration context. So that was my first category when it comes to dealing with international commitments. The second category, which is a category which would be familiar to all arbitration practitioners, is when private parties are now engaging in green technology, climate-related sort of investments. Now, these can be investments in renewable energy projects. All of them will qualify for the term environmental disputes. These disputes can be, again, subdivided into 4 or 5 different categories. The biggest example would be construction disputes, in which you're trying to set up a wind farm, you're trying to set up a solar grid. If there are any delays, defects, variations, all of these can lead to construction disputes that all of us dispute lawyers are quite familiar with. I ended up doing one such dispute in which our client, a European entity, had an EPC contract and an operation and maintenance contract with a Chinese entity for a wind farm. Now, the construction was actually all right. It was the operation which started having issues. And then the joint venture parties, they basically, they fell apart and it became quite messy, as a result of which the operator / contractor, he ended up switching off the wind farm. And the switch off was by way of actually turning off a button of a technology which is used to operate the wind farm, which was based out of China. Now, all of this is fine and it looks very simple, but my practical experience in dealing with that dispute was that it was very difficult to explain to the arbitrators who were deciding, because they did not understand what that technology is and how the causation element can be related to the operation issues. B, we had a huge difficulty in finding the right expert for it who understands this technology. And when that expert was put on the stand, the other side ended up getting some brownie points out of it. Because he didn't have that much of testifying experience. So these are the issues which you may end up encountering when you deal with new technologies which are untested. And given that commercial arbitration awards are not published outside, you don't get to see all these issues come out in the public domain. The second subcategory of disputes can be post-M&A joint venture disputes. For example, a private equity fund ends up investing in a renewable energy company, and then he wants to have an exit. In that case, what you have to be particularly concerned about are valuation issues, because how would you value a project which is completely nascent if you have, say, a hydrogen technology? Although I agree that there are some hydrogen projects which are already out there, but if you have hydrogen technology in a country like India, which is still quite nascent, how do you value when you can't even determine exact cash flows because of the lack of offtake agreements? The third kind of disputes would be plain, simple licensing and technology transfer disputes, in which a company, say in a developed country, is trying to establish a new technology in a developing country for which it has to do a technology transfer. Currently, Fuel Cell Energy, which is a US company, is engaged in a dispute with POSCO in relation to breach of the licensing contract. The fourth kind of disputes can be regulatory disputes, which are basically disputes between a private entity and a regulator. This can be in relation to feed-in tariff, something which Jennifer might allude to in her presentation, since investment treaty realm has seen a lot of it. But having said that, Government of Egypt has come up with a feed-in tariff system in which it has asked that all disputes in relation to that tariff system will go before the Cairo International Commercial Arbitration Center. Now, that leaves me with my final category of disputes which are pure commercial and do not have an environmental angle, but still might lead to one. Now, these can be, for example, a private equity fund in which the investment manager is investing, but is not compliant with the ESG guidelines, as a result of which the fund is held liable. And because the fund is held liable, an LP of a fund ends up suing the investment manager, which is most likely to be governed by a commercial contract. The second example is something which the ICC cited in its climate change report, in which it said that a contract was entered for the supply of tungsten, but tungsten could not be supplied because there was unexpected hurricane. And on that ground, force majeure defense was upheld. So these things, which are completely commercial contracts, can have environmental ramifications. What does it leave me? It leaves me with my final point, which are the practical recommendations. I already listed out quite a few of them. The first being that know the right arbitrator. The second being identify the right expert. The third being that users, when they are trying to enter into contracts, they should be very careful of environmental risks and factor it into contracts. The fourth being an arbitral institution should be open to coming up with tailored rules for environmental disputes. And fifth, be very careful about valuation of certain renewable energy projects because different risk factors might apply. With that, I will now ask Jennifer to tell us a bit more about the investment treaty realm of environmental disputes.
Thank you very, very much, Kartiki, particularly for the very helpful overview of environmental disputes and how environmental issues may arise in disputes. I think this sets the stage for me to address how tribunals in investor-state arbitration have grappled with these environmental issues as they arise. Before I begin, I wanted to acknowledge my colleague Ana Martinez-Valls for her invaluable research and help in my preparation for this webinar. One case, for example, was only in Spanish, so I wasn't able to read it, but she helpfully summarized it for me, and I was able to take it into consideration in preparing this for this webinar. So for the next 10 minutes, I will be speaking about environmental issues, disputes in investor-state arbitration. And over these 10 minutes, I would like to highlight 3 trends that I have observed from reviewing the kinds of cases that have come up relating to this topic. The first is that in the past, whereas in the past there were relatively few investment disputes that had environmental components, over the last 10 years, we've really seen a pretty big increase in the number of investor-state cases where such issues arise. The second trend that I saw was that environmental issues in the past were more frequently used as a shield, where states would raise it as a defense to justify the measure that is being challenged by the investor. Whereas increasingly, you see states using it as a sword, where they are affirmatively making counterclaims based on the investor's breaches of environmental law. You even see examples of investors alleging that a state's failure to enforce its own environmental protection laws constitutes a breach of an investment treaty. In introducing me, Kate had mentioned that I have worked on a case in which an NGO is bringing that kind of claim affirmatively as well. That's not in the context of investor-state arbitration, But that said, for example, the Peter Allett versus Barbados case, that's where an investor actually alleged that Barbados' failure to enforce its environmental laws destroyed the value of his investment and therefore breached the Barbados Canada BIT. So I will go into some of these cases in a little bit more detail, but I wanted to highlight the third trend that I've seen relating to this topic as well, which is that over time, tribunals have shown an increasing willingness to review and deal with environmental law issues. And this may be tied in part to the fact that we are also seeing increased reference to environmental protection measures in various bilateral investment treaties, free trade agreements with investment chapters, and international investment agreements. And I will go into a few of those as well. So I would like to take everyone on a bit of a chronological journey, I suppose. And the first case I wanted to talk about, just by way of example, is the SD Myers in Canada case, and that was decided in 2000. That was a case in which the investor had challenged Canada's ban on PCB exports, and PCB are a type of chemical that is toxic, essentially, to human health. And Canada maintained that human health and environmental health, and Canada maintained that this ban had been motivated by environmental concerns. In that case, the tribunal rejected this defense, holding that Canada's ban on PCB exports was not actually driven by environmental concerns, but was intended primarily to protect Canada's own PCB disposal industry from US competition. One might argue that that was a finding that was more on the evidence than on the terms of the treaty, in that case, NAFTA. But in another case, in Al Tamimi versus Oman, which was decided in 2015, you see that the tribunal actually accepted the state's defense that the challenge measures were justified to protect the environment, and the tribunal found in that case that this claimant's alleged losses and misfortune was really due to its own willful disregard of Oman's environmental laws. Likewise, in David Avin versus Costa Rica, which was decided in 2018, the tribunal also accepted the state's defense that the challenge measures, which were undertaken to protect the wetlands in which the investment was located, had been taken in accordance with domestic laws and international law. So that kind of shows how tribunals are increasingly willing to accept this defense and to accept that states are entitled to take measures in order to enforce their environmental laws, especially when investors have not complied with their domestic environmental law obligations. As for counterclaims, in some of the older cases, tribunals have rejected states' counterclaims on the basis that they lacked jurisdiction to hear them, or that the country did not have standing to hear them. And an example of that is the Rosoro versus Venezuela case, in which Venezuela had made counterclaims, environmental counterclaims, but the tribunal had rejected it, finding that in the terms of that particular treaty, only investors had standing to bring disputes before the tribunal, and they also found in any event that they did not have subject matter jurisdiction over the case. Fast forward a couple of years in Ubeza versus Argentina, you now have tribunals. The tribunal now accepts jurisdiction, but rejected the counterclaim on the merits, finding that there were no international human rights obligations which the claimants could have breached. In that case, Argentina had brought a counterclaim based on breach of the human right to water, and that sort of was treated as a human rights obligation, but the underlying investment in that case had to do with the sewage facilities and concession for water and sewerage services. Another case I wanted to talk about, or two cases really, were the Burlington and Ecuador cases, as well as the Parenco and Ecuador cases. And that's where, that was decided in 2017, 2019. And now you have tribunals upholding the counterclaims that Ecuador had made under Ecuador's own domestic environmental laws on the merits. Jurisdiction in those cases are a little bit different. It really wasn't an issue because Burlington and Ecuador had essentially agreed, and Parenco didn't challenge Ecuador's jurisdiction, Ecuador's standing or the tribunal's jurisdiction to bring those counterclaims. So in those cases, we see awards where tribunals are really assessing scientific and technical evidence and then making findings on the merits that those companies had in fact breached the environmental laws. So as I mentioned earlier, you have treaties that are increasingly referring to environmental protection measures as well. So depending on the way the treaties are worded, this may actually empower tribunals to consider environmental issues not just defensively when they're being used to justify the taking of certain challenge state measures, but also offensively in assessing an investor's liability for failing to comply with environmental obligations, or maybe in finding that they don't have jurisdiction because the investor hadn't made an investment. So a few examples of that would be the South African Development Community Model BIT template, in which they have a provision for minimum standards for human rights, environment, and labor, saying that investors and their investments shall not establish, manage, or operate investments in a way that's inconsistent with these obligations, with international environmental, labor, and human rights obligations that are binding on either the home state or the host state. You have provisions dealing with corporate social responsibility in the Indian model BIT, in the Dutch model BIT, and in the USMCA. And you also have in these BITs that I just mentioned references to how the tribunal should take into account any sort of unremedied harm or damage that the investor had caused to the environment as a mitigating factor when awarding damages. You have references to sustainable development in those treaties. So looking forward, I completely agree with Kate's and Kartike's remarks that ESG disputes are only going to increase going forward. And what would be interesting is to see how tribunals deal with defenses based on environmental protection measures, as well as how they deal with counterclaims based on breaches of environmental law. And an interesting idea that has been suggested is that just like one of the Salini criteria for what counts as an investment is the contribution to development, that maybe in the future, one might require that the investment have complied with international environmental obligations in order to enjoy the benefit of investment protections under treaties. So with that, I return the floor to Kate, who can then open it up to the other panelists. Thank you.
Thank you very much, Kartike and Jennifer, for your very interesting and informative remarks on environmental disputes. So let us now turn to social disputes, and we will hear from Devadas Satyanathan, Khushbu Shadatpuri, and Garay Lim. Devadas is a partner at Raja & Tann, Singapore. He started his legal career as a justice's law clerk and has been with the arbitration and construction practice at Raja & Tann since 2015. He has worked on a number of ESG related matters, including pro bono work with migrant workers and ongoing investor state and energy related arbitrations. Khushbu is a senior associate in Al Tamimi & Company. She's a dual qualified lawyer admitted to practice in Singapore and New York. Her practice focuses on international construction, infrastructure, and energy disputes. Khushbu also previously worked at the Office of the Prosecutor at the United Nations International Criminal Tribunal for the former Yugoslavia in The Hague. And she serves on the committees of the Greener Arbitration Campaign and the Racial Equality for Arbitration Lawyers Group as well. Garay is a partner with Drew & Napier. She practices international arbitration and commercial litigation. She studied law at Oxford University and is called to the Singapore Bar. And she was also named among Singapore's most influential lawyers under 40 by the Singapore Business Review. So Davidus Kushbu Gure, the floor is yours.
Thanks very much, Kate. Good morning, good afternoon, good evening, everyone. For those of you dialing in from Singapore, you might have just witnessed a tremendous downpour, which brings to mind environmental concerns. So it's far more intuitive to see what environmental issues are and correspondingly disputes. Social, on the other hand, tends to be overlooked, tends to be a bit more esoteric. We are talking things like human rights infringements to employment and safety conditions, D&I, diversity and inclusion, issues relating to child rights or child abuse, and modern slavery. So that's to set the stage. That's essentially what social disputes or social issues in ESG pertain to. That's not to say it's a closed list. The three of us have been discussing for some weeks now, and I think all we can conclude is S is simply what E and G are not, but that does not make S any less exciting. The three of us will be taking you through the world of social disputes in 4 parts in the next 20 or so minutes. First, I'll be running through some examples of social disputes above and beyond the categories just mentioned. Second, some legal and practical issues in the commercial arbitration space. Third, I'll be handing over to Kushbu, who will take us through the issues in the investor state arbitration space. And fourth, Gary will close this chapter on social with some lessons learned, handing over to Kate and after the governance team. So first, some examples. One way to break down social disputes is to categorize them into B2B, which is business to business, and B2C, business to consumer. In B2B, the focus is typically on combating abusive practices in supply chains, and we see more businesses either up or down, typically up the supply chain, taking on the role of watchdog or taking on some governance role. One example of this, to my mind, that has not led to a dispute yet is MasterCard's interaction with the porn industry. MasterCard imposed a requirement not on providers in the porn industry, but on banks, such that banks will have to ensure its consumers, which are in the porn industry, require clear, unambiguous, and documented consent in adult content. So that's achieving a social aim, which is, for instance, to lower the incidence of revenge porn being broadcast online through a commercial means, or one might say a social means. And a social dispute may well arise from this if, for instance, the banks are unable to meet that obligation in obtaining that assurance from its vendors. And it could well lead to arbitration based on an arbitration agreement between MasterCard and the bank. So that's an example of B2B. Second example, the second category is slightly more intuitive, B2C, where there's an arbitration agreement, for instance, in an employment agreement, and where the employee takes the employer to task or vice versa, and that goes to arbitration. That could also be fairly characterized as a social dispute, B2C, or in this case, employer and employee. Now, the second broad category of things our team is talking about, issues in the commercial arbitration space. At first blush, and this was a topic, a theme I think you'll see throughout this discussion, at first blush, arbitration seems inappropriate. That's for 3 reasons. First, It's private and confidential, typically not great for resolving things with a public interest dimension, and that applies across the board. E, S, and G, not great for resolving things that may affect third parties, so parties other than the arbitrating parties, or parties waiting in the wings to file something depending on the result of that first test case. So that's the first. It's private and confidential, and that's typically not great. Second, the issue of arbitrability, or whether something is suited to be submitted to arbitration. In Vietnam recently, well, not so recently, there was a court decision in 2018 ruling that a consumer had the right to defy an arbitration clause in a standard form contract and go to court. And recently, that decision was elevated to law in civil law Vietnam, which has to be abided by all Vietnam courts. Generally, what that means, in short, at the risk of oversimplification, is consumer is king. Consumer gets to choose between court and arbitration, even if there is an arbitration clause. In Australia, there was a recent case of Freedom Foods where it went the other way. An arbitrability type argument was attempted, but failed. So that's a finer point. The third problem with arbitration, privity, which relates to the first. It's hard to bind third parties. How do we get around these three problems? Broadly, the answer is to create a framework that allows parties to circumvent them. Two examples of this. First, the Hague Rules on Business and Human Rights Arbitration in December 2019. This was the outcome of a drafting project chaired by former judge of the ICJ, Bruno Simma, and embodies the expectations that social disputes resolved by commercial arbitration, specifically those relating to human rights, would increase and would need specific arbitration procedures to address them. And what these rules do is try to target the three problems that I just highlighted. They address things such as inequality of arms, the duty of the tribunal to satisfy itself of human rights compatibility of an award, transparency, and the like. There's also the Bangladesh Accords in 2013 with successive amendments in 2018 and 2021. This was on the back of a tragic building collapse, Rana Plaza, in 2013, and got the sign-on of 200-odd companies representing brands, trade unions, to work towards a safe and healthy garment and textile industry in Bangladesh. Again, the concept is similar. The set of rules, a framework. The limiting factor, of course, is this all requires sign-on. As with anything in arbitration, it can't be mandated. There has to be consent at the heart of it. So we've seen the constraints, and we've seen how parties have tried to, and governments, entities have tried to get around those constraints to make social disputes happen in a commercial arbitration setting. I'm handing over to Khushbu now, who will take us through the challenges and issues in the investor-state context for social disputes. Over to you, Khushbu.
Thank you, Devatas. Good morning and good afternoon to those joining in to the very first webinar of this year's YSIAC conference. So just getting right to it in social disputes. Now, the issues when it comes to social disputes, I think as Devatas mentioned earlier, is really they are vast, they are diverse, and they touch on anything related to societal needs, requirements, and rights. I won't belabor the point, but we'll leave it as it can be a little intuitive sometimes as to what actually constitutes social disputes. So how do social disputes actually arise in the context of investor-state arbitration? Now, generally the disputes arise from privatization of essential services or granting of licenses, concessions, to investors which form part of a government step towards improving its citizens' rights or livelihood. So when these rights that are granted are subsequently revoked through regulatory decisions, the societal aspect of dispute here comes either as part of the investor's claim for direct or indirect expropriation, as part of their argument that the measures imposed by the government contravene social rights. For instance, whether a community's access to clean water and sewage system was infringed when the government had imposed regulatory measures that impacted the concession that was previously granted to the investor. So the second way in which a societal dispute can manifest is as part of the state's defense to justify why it imposed these measures against the investor. And the states would very classically argue that these were implemented for the greater societal good. In one of the landmark cases that we were reviewing, the subject of the dispute pertained to measures that were imposed by a state to control the use of tobacco. And the state justified it to protect health, reduce high levels of smoking in its country. And the investor argued that this deprived it of its investment treaty rights. So that's one example. Legislations that are passed for labor, employment, welfare concerns, that's another example. Governments revoking mining license and concessions that were previously granted to investors on the basis of social unrest in local communities, where there are protests, looting, burnings. Unlike commercial or construction arbitration, in investor-state arbitration, societal disputes arise within the confines of an investor's claims pertaining to an investment which was allegedly expropriated, or a state's defense to justify why it had to impose these measures. So in terms of the legal and practical issues that have come up in the context of investor-state disputes, where social disputes are concerned, it is worth to expand on the concept of social license to operate. And this is a notion that in addition to the legal license granted by a government, the investor also needs to obtain or maintain a license from the local community where they are operating. And this concept is closely related to the responsibility of business enterprises to respect human rights. For a social license to exist, there must be legitimacy and underlying trust and consent between the local communities and the foreign investors coming into their space. Generally speaking, where there's reciprocity and this enduring regard for the other's interests, a company should be able to demonstrate that it has a social license to operate. And this is quite important because an investor can face community protests, security problems, and ultimately the revocation of government licenses if it doesn't manage to secure the social license. Each of these issues carry legal, reputational, and financial implications, which can serve detrimental to multinational corporations. In fact, the loss of social licenses to operate has been identified as a top business risk for companies operating in the mining and extractive sectors in 2019 and 2020. And as important as this is of a concept, it has not been clearly defined in international law. So international instruments are clear that there must be consultations with the local or indigenous communities for the purpose of obtaining this consent. But the extent to which an investor engages with all the relevant and likely to be affected local communities, and whether it would have obtained this social license had it been provided with the opportunity to invest the time and money to do so. Now, this remains a fuzzy area because the threshold really differs quite widely from region to region, community to community. Many times, in the cases that we reviewed, we see arguments, and really the crux of this issue is whether a mechanical adherence to regulatory procedures would give the investor social license to operate. I mean, it's not clear yet, and it's disputed in most cases that we have reviewed. In recent cases, investors have formed indigenous advisory groups to work with the investor and report to the board level. And this is quite a welcomed change that we would encourage and as a trend going forward. But what we need to look out for is whether these groups are actually afforded with the necessary power and responsibility, because without this sort of decision making, these sort of groups would be pointless and wouldn't have the necessary teeth to really make the changes going forward. A practical issue that has come up in the context of investor-state arbitration is the level of accountability and responsibility of an investor to deliver this sort of benefits to the community. And this is it's a topic that we can spend days and days speaking on. So I'll just touch very briefly on this. Neither BITs nor concessional contracts allow tribunals to find that an investor has an obligation to perform their requisite services in compliance with human rights. What we have seen is tribunals distinguishing between positive obligations to perform, which are only applicable to states, versus negative obligations to abstain, which are equally applicable to individuals and private parties. So such a distinction, what it does, it allows multinational corporations to evade from responsibility to deliver associated benefits to the community, because invariably the benefits to the community that the investment serves are positive obligations to do something rather than negative obligations to abstain from something, which then don't apply to investors. Just to sum up, really, the issues are twofold. The difficulty in holding corporations accountable for their impact on human rights and societal rights, and the difficulty in incentivizing corporations to adhere to these voluntary standards and ensure that this adherence is more than just lip service. And ultimately, this really begs the question of whether human rights performance standards can be set for foreign investors. Joy will touch on this and other related themes and share her perspective in the context of both commercial and investor-state arbitration. Over to you, Joy.
Thanks, Kushbo. And thanks, Devadas, as well, for both of you for the clear explanations about how social disputes arise in commercial arbitrations and investor-state arbitrations. So I think a common theme maybe that runs through both aspects of it is really this question of how do communities achieve or advance their desired social standards? And how do they really hold investors and businesses accountable to those standards? And then, of course, because this is an arbitration conference, what role does arbitration have in that process? So let me take up first investor-state disputes, because that's what we just heard from Kushbo. So I feel that ISD arbitrations are to a very large extent constrained by the treaty framework which gives birth to them. And that's because BITs are all about they're all really focused about protecting investors. The advancement of social goals in the host country is not really their primary focus. And when we then turn to investor-state arbitrations, this is generally speaking a one-way street in that it's always about claims by disgruntled investors. So that really means the investor is unhappy with something the government did to affect their investment. And so in the context of today's discussion, that's usually when the government tried to do something to alleviate social problems like increasing minimum wage. Let's say it mandated corporate ownership by local underprivileged groups. Let's say it cancelled investors' concessions in response to social unrest. So the government is the one that often, I think, ends up arguing in its defense to the claim that the measure which the investors are unhappy about was in the public interest. Or sometimes it might be the case that the government argues the investors' operations had flouted human rights or some sort of social rights such that the investment was unlawful. But again, this arises in defense to an investor's claim. Don't get me wrong, it's not impossible for investors to be aligned with the achievement of social benefits for the community. I think there was at least one case which has been mentioned where the investor was arguing that its concession would give the community access to water. And so the government's interference with that was preventing that social right. But really the majority of cases are in the other direction, where the government tried to do something which then maybe went a step too far. So in that sense, I think ISD arbitrations may not be the most effective mechanism by which society can positively use to advance social goals. And that's because ISDs are reactive to something the government did and which the investor does not like. You could see it as a form of checks and balance to make sure the government doesn't go too far in its measures. And just now, I think we heard from Jennifer from the environment team that some states have brought counterclaims against investors in the context of environmental concerns, and they claim that the investors breached environmental laws. But generally, counterclaims in ISDs can be tricky to establish jurisdiction. I think Jennifer was mentioning how the one or two cases where it featured, it was not really contested. And I think more importantly, ISDs don't give an avenue for the members of a disgruntled community to either compel an investor to meet social standards. Neither do ISDs give any avenue for the community to compel action by a lackadaisical government, let's say. And these points were mentioned by Kushbo as well. So an important stakeholder, which is really the community, has a limited role in ISDs. And this may not really be a criticism of the ISD process. I think it goes back to the underlying purpose of the BITs. Right now, BITs are focused on protecting investments, so it's very investor-centric. And one interesting potential area for change, perhaps in just throwing up ideas, might we see at some point a paradigm shift so that maybe the underlying treaties don't just protect lawful investments, but they are adjusted and structured so that they encourage or maybe even positively require socially responsible investments. That might even involve giving affected communities a role or a voice, which is currently missing from ISDs. Frankly, this would be a rather mammoth task. It's not a simple change. I don't know if it's feasible or possible. But it's an area where it might develop. Alternatively, maybe ISDs should have a primary role of being a tool for investors really to protect themselves and curb overzealous governments, and positive tools for communities to push for socially responsible businesses should come from elsewhere. And maybe this is where we look at the commercial disputes. So commercial disputes are a lot more flexible than ISDs because they aren't limited by the treaty framework or the defined categories of investment claims. So private contractual arrangements give room to set any agreed standards, whether it's human rights, labor conditions. They can confer benefits on third parties. And as Devas explained, I think this can manifest in B2B or B2C arrangements. Now, this is all still strictly speaking voluntary because parties don't, strictly speaking, have to include such things in their contracts for their primary business to work. But the push for the inclusion of social standards in contracts is coming from society as a whole. So customers and investors want to see businesses which adhere to high standards for social issues. And then this translates to a commercial reason for businesses to set such standards for themselves and their suppliers, because they ultimately want to keep customers and investors happy. And so we're seeing this through agreements like the Bangladesh Accords that Devatas talked about, where businesses are agreeing to mechanisms for trade unions and other stakeholders to hold themselves accountable, right? And then arbitration comes into the picture when that type of contractual framework or some sort of arrangement which underpins the relevant standard sets up the agreement to arbitrate. So one thought here is that, if ESG arbitrations are becoming more commonplace, they are more than a buzzword, I believe, as it was said, could that then shape and affect the arbitration process? Because taking a step back, public opinion is the primary force which is driving businesses to set and meet social standards in their operations. And as this is gaining more and more traction, it seems logical that the public, including customers, investors, stakeholders generally, would want to hold businesses accountable. They would not want their social disputes to be swept underneath the blanket of confidential arbitrations. They would want transparency so that everyone knows whether a particular business is meeting the standards that it professes to respect. So might we then see increased calls for transparency in commercial arbitrations, or at least for those which are about ESG issues? And this isn't unprecedented. In ISD arbitrations generally, there's already lots of articles and things like that, a lot of demands and movements towards greater transparency and accountability because of the wide public interest in state acts. And so trying to gaze into the crystal ball for ESG, we might see something similar happen to ESG arbitrations where there are also strong public interest elements. The alternative might be that if arbitration does not adapt to cater to pressures for transparency and accountability for ESG matters, ESG disputes might then move out of arbitration and into the courts. So I guess that was my closing thought, that it would be interesting to see how this all plays out. I think this was what the social team wanted to share, and it's back to you, Kate.
Thank you very much, Garay, Khushbu, and Devadas for your remarks on social disputes. And now, last but not least, we will discuss governance disputes. And we will hear from Tekwi Tiong and David Tavel on that. Tekwi is a partner in the corporate and commercial disputes practice at Wong Partnership. He's the co-head of sustainability and responsible business practice there. In the ESG space, Tekwi's main focus is on climate litigation and arbitration. And he recently delivered a seminar on climate litigation in Asia Pacific and its impact on business. David is co-founder and associated partner of the international dispute resolution boutique Rawthorne Legal, based in Frankfurt, Germany. His practice is focused on corporate governance disputes and industrial product liability cases in environmentally sensitive sectors such as oil and gas and energy. Prior to co-founding Rawthorne Legal, David was with Freshfields International Arbitration Group in Frankfurt and in Singapore. So Tekwi, David, the floor is yours.
Many thanks, Kate, for the kind words of introduction, and a good day to everyone. In this segment of the panel, we will discuss corporate governance disputes. I will start us out with a brief introduction as to what corporate governance actually is and how disputes look like in that area. and give some examples particular for the view of commercial arbitration. And then in the second part of the segment, Tekwi will shed some light on the intricate issues revolving around the issue of corporate governance in the space of ISDS, of investor-state dispute settlement. So starting off with the question, what actually are corporate governance disputes? Corporate governance traditionally is the system by which companies are directed and controlled. There is no clear delimitation of what that actually means. It is interesting to see that the meaning of corporate governance is changing over the years. The term corporate governance has been with us for quite some time, but it is getting a new meaning in the context of the broader discussion and the broader rise of ESG issues in total. And within the framework of ESG, corporate governance has quite a peculiar role so far. We've heard Devadas complain in the last segment that social aspects are a bit underrated when it comes to a broader view of ESG. Let me just, to put that into context, read from the Wikipedia definition of ESG. Wikipedia defines ESG as an evaluation of a firm's collective consciousness for social and environmental factors, full stop. So no mentioning of corporate governance even in that definition. And that kind of gives an interesting picture of the role that corporate governance plays in that discussion. It has been argued that corporate governance actually is less of at the forefront of the discussion. It is more the bedrock on which the discussion, which primarily revolves around environmental and social aspects, is based upon. And that makes total sense, because corporate governance, in essence, is the tool, the structure which companies use to enforce policies, which obviously also pertains to policies in the space of environmental and social aspects. So corporate governance is important to make sure that the aims behind ESG, particularly environmental and social aspects, are actually realized. And that currently is in a stage of being built up by setting up new corporate governance structures in the various companies. And that will, and that is a prediction, also play out in the field of dispute resolution. We will see an increase of disputes relating particularly to corporate governance, some of which will have a backdrop of the E and the S aspects, but others will also continue to revolve around the traditional aspects of corporate governance, which deals with disputes within the corporate structure of certain entities. How do these disputes end up in arbitration, you might ask? And we have been discussing in the previous segments certain difficulties for external stakeholders to bring their claims relating to ESG issues to arbitration, because obviously arbitration is based on consent and needs an arbitration agreement. So it is much easier for the traditional aspects of corporate governance, the disputes within one corporate entity, to end up in arbitration, because there we have various corporate documents like articles of association, bylaws, shareholder agreements, which can and often do contain arbitration agreements, creating a forum for these kind of disputes ending up in arbitration. And then we also obviously have corporate governance aspects which derive from just regular commercial contracts. And I will give some examples for those in a minute. But the underlying arbitration agreement is just taken from a simple commercial contract. And the third source of the power of a tribunal to decide corporate governance issues obviously relates to international investments, to ISDS, where then BITs or other international treaties are the basis for the tribunal's power to decide the dispute. And Tekwi will shed some more light on those in a minute. So moving on to a bit more specific examples of how corporate governance disputes may look like in the field of arbitration. I would suggest to make two distinctions between two factors each. The first distinction is between internal and external corporate governance disputes. Internal corporate governance disputes, as has been hinted at already, play out within the structure of a certain corporate entity. And here we have, for example, disputes between the shareholders and the board about board remuneration. That would be one of the myriad examples of such a dispute. And those I would like to call more of a traditional corporate governance dispute, which is not so much directly related with, broadly speaking, making the world a better place, as is true for particularly the E and the S aspects of ESG. Within this distinction between internal and external, the second category obviously are external corporate governance disputes, and those are disputes between a company and outside stakeholders. And those disputes are more directed, similar to the E and the S aspects of really changing the world. And for example, we have examples here going to board diversity, or also certain, to be more specific, certain corporate restructuring attempts which fail and result in the loss of employment for many people, and those aspects can also lead to corporate governance disputes, which then might be settled in arbitration, as the case may be, less with the employees and more between the actors of the corporate restructuring. The second distinction I suggested was between direct and indirect corporate governance disputes. And this goes back to a thought which I mentioned also briefly earlier. With the direct corporate governance aspects or disputes, the claimant directly invokes corporate governance related shortcomings, and really the dispute is focused on the corporate governance aspect. With the indirect corporate governance disputes, it is a bit different. There we have usually the before mentioned commercial contract, which forms the basis of the dispute. And here the claimant seeks normal performance of the contract or damages or whatever. And then certainly an element arises which sheds a corporate governance light on the dispute. And the mostly mentioned keywords here are bribery and corruption and money laundering, aspects which are also at the heart of corporate governance, and which can be relevant and are relevant to many international commercial contracts, and which have been the subject of arbitration proceedings quite frequently in the past. And it is poised to be that this will continue and even rise, because the sensitivity for these issues is rising with the rise of ESG and the view that society has on these aspects. Now let us get a bit more specific and address some of the legal and practical issues which can arise in these disputes. And obviously the variety of these disputes is too large to fully address all aspects that can be relevant. So we decided to focus on two scenarios here. First, I will give you one example of my recent practice concerning a contribution in kind gone wrong. And then we will briefly shed some light on the relevance of bribery and corruption in commercial arbitration. And then later on, we will also take on that issue and we will explain to us the relevance of this particular aspect also in ISDS. Starting out with the example of, like I put it, a contribution in kind gone wrong. So the story or the case is set in the early 2000s, and it revolves around the consumer imaging industry. And as you might recall, or some of you might recall, in the early 2000s, there was quite a tectonic shift between or from analog to digital photography. And that obviously had a huge impact on the industry at large. And as part of that shift, certain players, big players in the market, decided that their analog consumer imaging branch is not profitable anymore, and they tried to get rid of it. So they decided to carve it out and sell it. And the way that the corporate restructuring went, they decided to do a contribution in kind into a shelf company. So they basically carved out the entire consumer imaging business, put it into a shelf company, and then sold it with a bit more of a complex structure, but I'm simplifying here. And a few months later, the new shelf company with the consumer imaging bit in it ended up bankrupt. So many people lost their jobs or were at risk at least, and it was a difficult situation there. And that risk of really getting rid of a non-profitable part of business, putting at risk the jobs of the employees, putting at risk the interests of other stakeholders by way of a corporate transaction, is also an aspect which is relevant from the perspective of corporate governance. In this particular case, the contribution agreement contained an arbitration agreement. So the insolvency receiver ended up initiating arbitration proceedings against the parent company who did the contribution in kind, the contributor, and the arbitration is ongoing, and obviously it has very difficult valuation questions, because what the insolvency receiver is seeking is recovery of the difference between the value that the consumer imaging part, the contribution, should have according to the contribution agreement, and the actual value of the consumer imaging bit, which obviously, as is confirmed by the insolvency and the bankruptcy, has been much lower than what was agreed in the contribution agreement. And this difference in value is obviously very difficult to determine. And this determination of value, this quantification of the claim, is also closely related to the corporate governance structure set up between the parts of the industry. To just very briefly shed some light on bribery and corruption, and then to hand over to Tekvi. Bribery and corruption in commercial arbitration is less of an issue for jurisdiction, because, as you all know, due to the doctrine of separability, the fact that the substantive contract is tainted, for example, by bribery, does not affect the arbitration agreement. It can, however, be an issue for the substantive validity of the contract. And in determining this, questions of proof are very important, because oftentimes there is no real evidence for the bribery, and we have to look at circumstantial factors. And to this end, it often turns out that there are, in cases where bribery is an issue, that there are criminal proceedings running in parallel to the arbitration. And then obviously it's important to look out for the content of these criminal proceedings, and for the progress it makes to make use of the evidence that surfaces in these proceedings, also for the arbitration. And with that, I hand over to Tekvi, and thank you for your attention. And I think Tekvi will also continue to discuss the interesting and intricate issues of corruption and bribery.
Thanks, David. Hi, everyone. Good afternoon again. I'll just pick up where David left off. So yes, indeed, the preponderance of how corporate governance disputes or governance disputes manifest in the context of investor-state dispute resolution primarily revolves around allegations of bribery, corruption, as well as illegality. And I think in this regard, there are two ways to look at it, right? First, the types of allegations that are raised by investors bringing the claims, and the types of allegations that are raised by states, not necessarily as counterclaims, but perhaps as defenses. On the part of the investors, a quick survey of the cases show that most of the time, what you see are allegations of corruption in instances, for example, in the awarding or expropriation of licenses for, say, the mining, coal exploration, oil exploration, or, for example, allegations that certain acts of expropriation are politically motivated, or certain regulations that have been introduced that impede with the investment are politically motivated. So those are the sort of allegations that one commonly sees investors raise in the context of governance disputes in ISDS. On the government side, on the state side, these allegations are usually raised as defenses. So, for example, that the investments were procured by fraud because the investor had paid a bribe, or that the investment is fundamentally illegal because it was not made in accordance with the laws of the whole state, or that following the entering into the investment, there was various illegal acts that were carried out. Say, for example, the investment was being used for illicit purposes like money laundering. So that's just a very broad overview of the type of governance disputes in the context of ISDS. And as I mentioned earlier, they tend to revolve around issues of bribery, corruption, and illegality. Now, these issues in the context of ISDS disputes are certainly not new and have been around for much longer, for a very long time, sorry, and certainly well before, as the speakers that have come before me said, ESG became a buzzword in the legal sphere and in the space of arbitration. So what are some of the legal and practical issues to take note of in the context of governance disputes in ISDS? I'll suggest one for each. So in the context of claims of allegations of corruption or bribery brought up by the investor against the state, one of the key issues that we often see is a very practical one, and that is evidentiary. How does an investor, in fact, go about showing that certain regulations promulgated by the state or certain measures that were taken by the state were motivated by bribery, by corruption, or politically, right? That's probably the hardest one. How does one show that there were extraneous and non-genuine or non-bona fide motivations behind the introduction of certain measures or legislation? And whilst discovery does afford an avenue for investors to get their hands on the evidence that they need to prove their claims, the issue is also that states have often raised in discovery applications issues of secrecy, confidentiality, and discovery is not necessarily one of the easiest ways for investors to lay their hands on the evidence they need to support their claim. And where such claims have been brought successfully by investors, usually they belong on the more slightly egregious end of the spectrum, where there are extremely clear or very clear examples where the measures in question were politically motivated or motivated by bribery or corruption. And of course, the key example that comes to mind is the case on everyone's lips, UCOS, which has just seen very interesting recent developments, where it was of course found that it wasn't found in the case of UCOS, the tribunal did not find on any particular fact that the expropriation was inappropriate, but it was a combination of numerous factors, even down to something as seemingly innocuous as a remark made by President Putin in a conference that UCOS has a lot of resources, Rosneft has very little resources. Go figure the rest out yourself. Which I think I'm paraphrasing, but I think that was the gist of what President Putin actually said, and that weighed on the tribunal's mind, right? So, but anyway, the long and short of it is that it is not easy for an investor to prove corruption, bribery, or any allegation of similar ilk in the context of ISDS disputes, and evidence is certainly an issue. Now, turning to the side of the state. Now, the state would, of course, often raise issues of corruption, fraud, etc., as a way of defending against claims brought by investors, and this could happen at three stages. right? And I think most of us who have done work in investor-state disputes will be familiar that this is certainly one of the key issues in investor-state disputes, where there is an allegation that an investment is tainted by corruption, bribery, or illegality. How should that be resolved? Now, this can be resolved in three ways. First, as a jurisdictional question. Secondly, as an admissibility question. And thirdly, of course, in the merits phase of the arbitration. Now, the distinction between when a tribunal would deal with such a question in the jurisdictional and admissibility phase is in those two phases versus when the tribunal will deal with it in the merits phase is a lot clearer, right? So the distinction is simply where the alleged acts of corruption, bribery, or fraud happens after the investment is entered into and doesn't taint the inception or the formation or the entering into or the acquisition of the investment. So, for example, cases where companies were set up and later on were found to be shell companies for money laundering, allegations like that would go into the merits phase, or would clearly go into the merits phase of the arbitration. Now, what is more interesting is when does the tribunal then deal with this question in the jurisdiction phase, and when does the tribunal then deal with the question in the admissibility phase? Now, admittedly, the approach applied by tribunals when one surveys the cases, the approach applied by the tribunals across various cases is different, inconsistent, and that in and of itself is problematic. But I think I would prefer certain broad views as based on my own research and survey of the cases as to when tribunals have dealt with this question as a jurisdictional question and when tribunals have dealt with it as an admissibility question. Now, in terms of when the tribunal has dealt with this as a jurisdictional question, the leading authority is of course the case of Metal Tech, where you see that the tribunal dealt with this as a jurisdictional question because the BIT in question contains an explicit legality requirement that the investment needs to be made in accordance with the laws of the host state. And if the investment was tainted, or the acquisition of the investment or the making of the investment is tainted by fraud, bribery, corruption, then it follows that it would not have been made in accordance with the laws of the host state. And it therefore affects the tribunal's jurisdiction to hear the matter, or it affects the consent to arbitrate that is within the BIT itself. Now, how about when tribunals deal with it as an admissibility question? It may perhaps be a little bit simplistic, but I would suggest that tribunals would deal with this question as one of admissibility, where there is no real express requirement in the BIT that the investment is made in accordance with the laws of the host state. But in any event, the tribunal finds that it would be inappropriate to allow the claim to be brought for policy reasons, that the tribunal cannot be seen to condemn any acts of fraud or bribery or corruption which are internationally sanctioned and frowned upon, and that the tribunal will not vindicate any of these actions. So on that policy basis, so for example, in cases like World Duty Free and Kenya, Churchill Mining and the Republic of Indonesia, on that policy basis, the tribunal in those cases were prepared to find that although they had jurisdiction, the claims were not admissible for that particular policy reason. So just very quickly, of course, many issues abound in investor-state disputes concerning governance disputes, bribery, corruption disputes. There are many issues, but for the purposes of today's presentation, I'll just highlight a couple of those. In terms of looking forward, one interesting issue in the context of ISDS disputes and bribery and corruption disputes is where states attempt to use their own acts of corruption as a defense against the claims. Now, of course, you have cases like YSIAC and Egypt, where, I beg your pardon, where the tribunal clearly held that the state cannot rely on its own wrong to block an ISDS claim, but you also have cases to the contrary, and this is a real issue because it goes towards long-standing complaints with the ISDS system being weighted towards states, and this is one of the this adds on to the litany of complaints against the ISDS system for being weighted towards state. So this is certainly an issue that one would have to keep an eye on in future. So just to quickly wrap up David and my segments, in terms of where we see governance disputes moving forward into the future, on governance disputes in commercial arbitration, as David mentioned, one can sort of broadly divide it between internal and external disputes. And on internal disputes, the way we see it moving is that as disputes grow in volume, complexity, and quality, there is a need to set up some sort of a functional dispute resolution regime aligned between the various corporate players and the relevant, taking into account the relevant underlying corporate documents, and to take into account whether softer forms of or alternative forms of dispute resolution may be appropriate and lead to a faster and smoother resolution of the disputes. Not bearing in mind that we are talking about people of diverse interests within the corporate structure. You have your shareholders, you have your directors, you have your investors, you have your creditors and debtors, and everyone has slightly different interests, and bringing everyone together to resolve the dispute in a holistic fashion may require something a little bit softer and an alternative form of dispute resolution. For external governance disputes, the key takeaway, I think, will be to look out for parallel proceedings, particularly criminal, regulatory, or administrative proceedings, comments against the company for those exact same set of facts. All in all, we think that as David started off this particular segment, that corporate governance is the key tool to ensure companies' compliance, not just with prevailing regulations in relation to ESG and sustainability linked issues on the environmental and social front as well, but in terms of allowing stakeholders in the corporate structure to hold the company accountable to its goals, and for the company to use that as a roadmap and as a structure to meet its own sustainability and ESG linked goals that it has set for itself. Yes, so I think that brings us to the end of this segment. So back to Kate.
Thank you very much, Tekwe and David. And this is actually the end of our webinar. What's left for me is just to say thank you to the panelists for their insights on ESG disputes and resolving ESG disputes through international arbitration. And thanks to our supporting organizations, to SIAC and to the Young SIAC Group for helping organize this event. And finally, thanks to you in the audience for joining us today. We hope you all enjoyed our webinar and have a good rest of your day. Goodbye.